Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court, put him in jail.
All right, guys. Today we've got one of the most disrespectful sovereign citizens we've ever seen on this channel. This guy has a massive ego and straight up refuses to answer basic questions from one of the most respected judges on YouTube, Judge Oakley. It's honestly wild watching how he thinks he can just ignore the law and talk in circles like that's somehow going to work in a courtroom. But Judge Oakley handles the situation like a complete professional, calmly shutting down the nonsense and putting this sovereign citizen right back in his place. While you're watching, let me know what you guys think. Did Judge Oakley handle this perfectly? Or do you think he should have been even tougher with him? Rate the judge's performance from 1 to 10 down in the comments. Now let's go ahead and dive into one of the most intense court hearings we've seen yet.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, what? Are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I have recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
Understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today,
Do you have a jurisdictional argument you want to make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple-
no?
This right here shows one of the biggest issues people often notice with individuals who claim sovereign citizen beliefs, because many of them spend their time twisting courtroom rules and speaking as if they are acting in some low-budget courtroom drama. Instead of taking the hearing seriously, the behavior often comes across as confusing, staged, and difficult to respect, which is why a lot of viewers find it frustrating to watch. I want to make it clear that I am not connected to sovereign citizen beliefs, but if someone ever stood in court with that mindset, the smartest approach would still be simple: respect the judge, listen carefully, and answer questions directly, because the courtroom is not a place where avoiding answers helps anyone. Refusing to respond clearly only makes the situation worse and can easily lead to consequences like contempt of court, which only adds more trouble to the case. This does not mean every person who holds those beliefs is the worst type of person, but the reality is that showing basic respect and cooperating with the process would instantly improve how they are viewed inside the courtroom. Many people watching would probably be more willing to listen if the person simply stayed calm and responded to the judge in a normal way instead of refusing to answer simple questions, because when someone continues to avoid direct responses, it creates the impression that pride and ego are controlling the situation rather than logic or strategy, and that type of approach rarely helps a legal case move in a positive direction, while the court is simply trying to get clear answers and move the hearing forward in a fair and orderly way.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law.
Which
it's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it? For the
My
record, I need to
jurisdiction
have
is
it
both
on-
civil-
I can't defend myself unless I have it on the record. Is it?
My
It's
jurisdiction.
only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party.
Right here, this man begins arguing that a criminal case cannot exist unless there's a visible injured person standing in court, and that idea shows a complete misunderstanding of how the legal system actually works. In reality, the injured party in many criminal cases is the state itself, because when someone breaks the law, the harm is considered to be done to society as a whole, which is why the judge calmly explained that the injured party represents the people of Michigan. The courtroom does not require someone to walk in showing physical harm for a law to be enforced, because laws are created to protect the public and maintain order across the community. Thinking that a case disappears simply because no person is standing there claiming injury is like believing a bank robbery becomes acceptable if the building does not file a complaint. That kind of reasoning ignores how criminal law is structured, and it only slows down the court process while officials try to move the hearing forward. Viewers watching this moment can clearly see the judge patiently clarifying a very basic legal principle, while the defendant continues presenting arguments that do not align with real courtroom procedure, and it leaves many people wondering whether this misunderstanding comes from confusion or simply from refusing to accept how the law actually operates. As the hearing continues, the situation becomes more tense, and it will be interesting to see if the defendant changes his approach or continues, presenting the same arguments while the court moves forward with the case, and the judge maintains control of the courtroom atmosphere as the discussion continues to unfold further in the hearing.
Who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steffen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says it's
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied.
This moment clearly shows why many viewers appreciate the way this judge manages situations involving people who challenge the authority of the courtroom, because he keeps the proceedings focused and does not allow the hearing to drift into long arguments built on confusing interpretations of the law. His style is direct, confident, and controlled, which helps maintain order when someone attempts to redirect the discussion away from the actual legal issues. During a previous discussion, some viewers mentioned that his tone felt too sharp, yet others believe that a firm approach is necessary when a person repeatedly ignores standard courtroom procedure and continues presenting the same arguments that do not move the case forward. In moments like this, the judge stays calm, but also makes it clear that the courtroom operates on established rules, and those rules apply to everyone who stands before the bench. Supporters of this style often feel that clear boundaries prevent the hearing from turning into a spectacle, while critics sometimes prefer a softer tone. However, the judge continues guiding the case step by step and reminding the defendant that the legal process is not a stage for endless debate, but a place where real decisions are made and consequences are determined. As the hearing continues, viewers remain curious to see whether the defendant will adjust his behavior or continue presenting the same arguments while the judge keeps the proceedings moving forward with authority and structure.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing, and that I did not.
They're the same thing, Mr.
It's
Michaud.
still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary
Have you
exam.
ever had a grilled
If
cheese?
it was different,
Have you ever had a grilled cheese?
if it was different, why would it have two
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not gonna let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
I understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not gonna talk over him.
Right.
And I'm not gonna play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you gotta be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it? If it's a hearing, or
You
a conference,
didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's no
to prepare,
preparing for a probable cause conference. It's a conversation.
it still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
Honestly, watching this moment makes you wish the camera would show the reaction on his face, because the amount of time being spent just trying to explain something as basic as a probable cause conference is almost unbelievable. It is not some complicated legal mystery. It is simply a step where the court reviews the situation and decides whether there is enough evidence for the case to continue forward. Yet this man is treating it like he needs weeks of preparation, as if he is studying for a major legal exam, and the whole moment where the judge uses the grilled cheese example makes the situation even more memorable, because you can almost imagine the judge trying to think of the simplest way possible to break the concept down. So it finally makes sense. It feels like the judge reached a point where he thought maybe a very basic comparison might help the message land. Yet even with that effort, the explanation still seems to bounce right past him, which leaves everyone watching wondering whether he truly does not understand what is happening, or if he is intentionally acting confused in hopes of delaying the process or avoiding responsibility. Some viewers might believe it is genuine confusion, while others might think it is a tactic to stretch the hearing and create more chaos. But whatever the reason, the situation makes the courtroom look like it is stuck repeating the same explanation again and again, while the judge keeps trying to move the case forward, and the audience can only sit back and watch the tension build as the hearing continues, and everyone waits to see whether the next moment finally brings clarity or creates even more frustration inside the courtroom.
Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date, and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam, and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
as you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
the bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay, listen. You can't tell me something and then just disagree with me and think
okay.
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run.
This hearing honestly should have ended many minutes earlier, yet the situation keeps stretching longer because this sovereign citizen continues turning the courtroom into a stage for his endless speech as if he is delivering some long presentation instead of responding to a simple legal process. It is surprising to watch someone stand in front of a judge and behave as if the judge is there to serve as his personal instructor, demanding explanations for basic procedures that any attorney could have explained to him long before he ever stepped inside the courtroom. It reaches a point where people start wondering if this confusion is genuine misunderstanding or if it is simply a tactic to slow everything down and create more chaos during the hearing, because the judge is clearly trying to keep the discussion focused and move the case forward, yet the constant interruptions keep pulling everything backwards again and again. The patience from the benches noticeable, but even that patience has limits, and when someone keeps ignoring basic courtroom conduct, it becomes harder to believe the behavior is accidental. If the interruptions continue, the judge may decide that a stronger response is necessary, because sometimes a short stay in custody becomes the wake-up call that forces someone to finally understand the seriousness of the situation. Now the only question left is whether this man will finally quiet down and cooperate with the court, or whether he will keep pushing the situation further until the judge decides enough is enough and takes stronger action.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am
recognize
not
any
a
of that.
United States citizen. I am
Stop,
actually
hold
an
on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It should mean something
Can
because,
you prove it? Please prove it.
can I prove what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Hold on, you've asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
asked
proved
you
it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay?
you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen
you
to
have,
me. Mr.
you
Michaud,
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
Just like that, the judge delivers a 30-day sentence, and the moment lands like a loud wake-up call for anyone who still believes courtroom tricks will beat the legal system. This situation shows very clearly that standing in front of a judge with attitude and confusing arguments will not lead anywhere, especially when the judge understands the law far better than the person trying to challenge it. This man walked into the courtroom acting like he had discovered some secret strategy and believed he could control the entire hearing by demanding explanations during a basic probable cause conference. Yet the truth is the process was simple, and all he needed to do was respond calmly and answer the straightforward questions placed in front of him. If he had done that, he likely would have walked out of the courthouse without any additional trouble, but instead he decided to challenge the process and create confusion, hoping the judge would somehow lose track of the case or back down from the situation. That plan collapsed quickly because the judge patiently explained every detail and finally made it perfectly clear that the man standing in the courtroom was indeed the same person named in the case. The logic was simple and impossible to deny because he had already stepped forward when his name was called, which confirmed his identity beyond argument. What makes the situation even more surprising is how strongly he believed his secular arguments would somehow overpower the legal process, yet the only thing his behavior achieved was landing him behind bars for a full month. This outcome sends a strong message that the law is not a suggestion and a courtroom is not a place for games. Judges like Oakley focus on facts and procedure, and when someone refuses to follow simple instructions, consequences quickly follow. This entire hearing became a clear lesson about responsibility, respect, and the limits of personal ego in the face of established law. Now the discussion continues among viewers about whether the judge acted too harshly or handled the moment exactly as needed, but many people feel the response was balanced and appropriate because the court cannot allow its process to turn into chaos. In the end, the hearing stands as another reminder that preparation, honesty, and respect for the court will always lead to better outcomes than arrogance and confusion, and for anyone watching it becomes obvious that challenging the system without understanding it rarely ends well. Thank you for watching and supporting the channel. Your time and attention are always appreciated, and more discussions like this will continue soon. So stay tuned for future updates and deeper looks into real courtroom moments like this one.